Hey, good afternoon, everybody. It is November the 8th, 2024, and we are starting into training 6 of the Family Forward Project Advocate Training. Let me see if I can get us up here and going. Get our slides going, and we will start talking today. I'm going to have a few people again try to jump in while we're in the session, which is okay. It just is a little bit of a hiccup and distracts me for just a second, but that's fine. We'll just keep going. All right, we are going to talk today about CPS litigation preparing witnesses. Now, we already had one of our trainings. We talked a little bit about objections while people are testifying. That was also very important. Uh, Testifying, evidence, objections. These are things that you cannot train yourself too much on. You just need to look at them over and over and over. And I'll tell you, and I think I said this before, there are attorneys that do not understand evidence and they don't understand objections very well. So if you can go back and look at the tricks and tasks and talking about objections, go back. I have prepared the quiz on that. I have done the quizzes on all the ones that we've done so far. Those are up in Classroom. I posted all the classroom links in Family Forward Project as well. But I went through a list of objections, and we're going to talk about that again, but we're going to talk about it a little bit differently and from a little bit different angle, and really taking a look at all the different kinds of witnesses that we're going to be dealing with in CPS litigation. So, first of all, testimony is evidence. Now, I'm going to share with you, some of my most humble moments that I've had in my 28 years of practicing. And so I remember when I first started acting as a district attorney and I was prosecuting domestic violence or some trial I was preparing for, and I was looking at the woman who was my trainer, and I'm like, we don't have any evidence. And she's like, testimony is evidence. So remember, testimony is evidence in a trial. And one of the first things I wanted to talk about is just there can be a wide cast of characters that become witnesses, even in CPS litigation. They can come from all different walks and professions of life. Their ability to communicate differ. They're listening, they're responding, they're organizing, their thoughts are all different. So, as we go through this, just always keep in mind that courtroom testimony is not a conversation, okay? There's a lot of tricks that defense attorneys try to use to create conversations to trip people up, but there is a very, very specific purpose of testimony. So, always just put that in great big letters if you're taking notes today, that courtroom testimony is not a conversation. So, virtual testimony, I think, is the beast. So, during COVID, we had the blessing and the curse of Zoom hearings. And I am going to tell you, I was one of the very first attorneys that ever had to do a trial by Zoom way back in March 2020. As soon as they shut the court system down, I already had a trial that was set up, and the judge insisted on going forward. And I was like, okay, I know there's going to be some problems here. I don't even know what those problems are going to be. And I'm going to talk a minute about what they are. But it is a blessing to be able to use Zoom or some type of virtual medium to be able to make third-party witnesses available. But the curse of it is there's always a problem with the quality of the logistics, the separation from the client, and the lack of presence. So the last two are the most critical when trying to do any type of a Zoom hearing. The separation from the client. Now, typically, when an attorney sits in the courtroom, their client sits right beside them. And as you go through the process of litigation, I mean, before I even stop asking questions, my client is writing me notes. I'm leaning down and I'm asking, is there anything else you want to cover? I'll say, Your Honor, can I have a minute? And I'll talk to the client. And so this separation from the client always makes it difficult. That's why a lot of times what has happened is when there is some type of a Zoom hearing, the clients are actually going to their attorney's office. and then the two of them together are just sitting on the Zoom together. So if you're ever required to do a Zoom hearing, especially if it means that the attorney is going to be separate from the client, you need to think about that as a critical issue. And, if you have somebody that you're advocating for and this happens, you need to talk to them about, look, you're not going to be able to talk to your attorney or pass your attorney notes or have your attorney speak to you. Now, actually, I have used the phone, right, and passed text messages back and forth while they're doing testimony. Very, very difficult to do. The other thing, the lack of presence, there is something to be said about having your witnesses there in the courtroom. And I know, golly, after all the hundreds of Zoom hearings and meetings and stuff that we've done now, that, you have people, and you can see like these two dudes over here in this on the side. Now, I think this is probably a video of what do you call it? A reaction video where they're reacting to this court hearing. But, you'll have some witness showing up where they're like, they've got this strange background going on, or, they're wearing hats and they can't hear you. So, um, there's a problem with not having the person right there in the courtroom where you can have that conversation with them. You can actually, as a lawyer, or as somebody trying to act pro se, you can control it a little bit better if they're right there in the courtroom with you. So basically, there are four types of witnesses. Let me put this down out of my way. Basically, four types of witnesses. So there are non-party witnesses. So the persons who are not named in the legal documents, the persons who do not have their rights at risk. So these would be the people in CPS litigation that are not the parents. Okay, it could be a lot of other people. It can be caseworkers, teachers, etc. But the people, those are non-party witnesses. There are expert witnesses, the persons who have advanced knowledge in an area that will assist the trier of fact, being the judge, in understanding or explaining complex facts. There are party witnesses, persons who are named in the legal documents, typically in a CPS case, it's going to be the mother and the father. And those are the persons whose rights are at risk. And then there's child witness or children who are witnesses. And there's a distinction between children who are under 12 and children who are over 12. And we'll talk about that. So the order of proof in litigation is the person who files the complaint gets to go first. So they put on their case first. That will be called the plaintiff or the petitioner. In CPS cases, the state agency is the plaintiff or petitioner, and they put on their evidence proof witnesses first. And the state agency will likely call the parent as a hostile witness. So the state has what's called the burden of proof. In other words, they have to prove their case. The defendant is the respondent, and the parents are the defendants. The defendants put on their case after the state agency. They have no burden of proof. And then the rebuttal is the plaintiff has the opportunity to call witnesses to rebut any facts that the parents put on. Now, sometimes the courts will allow, especially if it's non-jury, they'll allow what's called a surrebuttal. So then the defendant or the parents can put on some additional proof if they need to. This is unfortunately, this gets entirely out of hand. And if people have prepared their case in advance and they have already done discovery and they know who the witnesses are and what the evidence is going to be, you really should not be having that problem. All right, I want to go back to these two statements here about the burden of proof. So the state is going to have the burden to prove their case, and in dependency cases and child abuse cases, it's typically a clear and convincing evidence standard, which means that it's more than a preponderance of the evidence. That the parent does not have a burden of proof. But do not be tricked by that, okay? Do not be tricked, because if the state gets up there and puts on a witnesses and, basically says, these are the worst parents in the world, they don't do the dishes or mow their yard or feed their kids or whatever, right? If the state gets up there and says that, that's evidence, that's proof. And if the parents are not prepared to defend the allegations against them, they're going to lose, even though they don't have the burden of proof. Even though the state has the burden of proof, they can just get up there and have these people testify about stuff, and the parents don't have a defense. So preparing a defense is critical. So last time we talked a lot about what kind of evidence you need, phone records, text messages, medical records, school records. The parents need to be prepared to get this. Some of the best cases I've had are parents who, for instance, this one mom, CPS came after her. And, golly, as soon as the case got started, the first thing she did was go to school and get their school records and show how much she had participated in school, get their medical records, show how much she had taken care of them, right? So the parents cannot sit around and do nothing thinking it's not my case, it's the state's case. So the state's going to have to prove their case. And unfortunately, a lot of attorneys sit on this and don't really prepare an effective defense. All right, so when you think about going to prepare a presentation, especially a presentation where there's more than one side, any type of presentation. I also did psychology master's work before I went to law school. So some of the psychology effects of this are pretty interesting and important, I think. So there's a primacy, recency, and serial theories of memory. Okay. So the recency effect and the primacy effect are two components of the serial position effect, which is a phenomena in which the position of items on the list influence how well those items are recalled. The recency effect is the tendency to remember the most recently presented information. Oops, hold on. Somebody wants in. Somebody's knocking on the door. The recency effect is the tendency to remember the most recently presented information best, while the primacy effect is the tendency to remember the first few items on the list better than those found in the middle. The recency effect is dependent on short-term memory, which is the ability to hold a relatively small amount of memory in the mind for a brief period of time. Okay, bottom line, what does that mean? It means when you are presenting a case to a judge, is the judge going to be more interested and more attentive to what he hears first or what he hears last? Okay. So, we have this, over the years, we've been able to point out, we characterize judges, and there are some judges that basically we say whoever speaks first wins, because the judge is so affected and is so, their mind becomes made up on what's first told to them. So again, going back to the slide we looked at before, if it is the state's case and the state is putting on their proof first, and they put people up on the stand that say, oh, these lousy parents, they don't feed their children, they don't go to church, they smoke pot, they do this, that's the primacy effect, where you're affecting and you're putting into the mind of that judge. The very first thing is to just make these parents look like crap. Okay. So there are certain things that you can do if you're very attentive. A parent should learn to be very attentive to this, as well as lawyers. But there are certain things that you can do to kind of watch and watch the kind of feedback and response that judges make, or the way they treat witnesses, and you can kind of tell what's going on. And so overcoming that is to be very specific about attacking each and every item that was given at first, so that you can undermine that recency effect. So in other words, the judge is creating this horrible concept of the parents about the way they eat, they, don't do homework with their kids, whatever. Is you have to identify each one of those and be prepared to put on a defense to every single different one very methodically. Now, the primacy effect is kind of what did they hear last, right? And so again, the state gets to present their proof, the parent presents their proof, and then the state gets to put on rebuttal. So they're hearing the state first and last, which is another, unfortunately, has a detrimental effect on the parents and in trying to prepare a defense. So because the parents are caught in the middle of that process, That is another reason why it is so critical that their cases are very carefully prepared. All right, so about witnesses generally. So some just generally as you're learning about witnesses here, just some things to think about, sort of the categories of what you need to know. It's kind of who is going to call the witness to testify. What is the difference between direct versus cross-examination questions? What is the difference between open-ended versus leading questions? And knowing what it means when somebody cannot recall details and they say, I don't recall. When a witness can say yes or can say no or can ask to explain. How important it is in listening to the questions and then being sensitive to the tactics of opposing counsel and understanding that witnesses need to control their emotion and anger in their responses. Very hard to do sometimes, actually. Very hard to do. I've had to do it before. Oops. Sorry. Flipped ahead. All right, about witnesses and documents. So we've talked about this before in Tricks and Task about preparing, having your parents document with calendars and notes and recordings, etc. So witness notes and calendars. So there is such a thing in evidence called, and this is a technical term here, present, recollection, recorded. Okay. So present, recollection, recorded is basically a diary, right? Or a calendar. So a witness can look at something that when it happened, present recollection means when it happened right then. So when it happened right then, did they make a note? Or when it happened right then, did they make a phone call? If so there's uh so if they presently at that moment recorded their recollection, it's something important for them to be able to have available to testify to. All right, and there's a difference. The second thing there says anything. So refreshing your recollection is a little bit different than present recollection recorded. Okay, this is another legal term, refreshing your recollection. So you can refresh your recollection with anything. Okay, with anything. Let's say somebody has asked the question, so what night did you eat at Taco Bell? And the witness is like, I don't remember. I can't remember what night it was. And somebody, let's just say, or your client previously gave you a receipt from Taco Bell, you can say, well, if I handed you this receipt would it refresh your recollection? And they say yes. And so you hand them the receipt, they look at it. They didn't have to create it. You just go like, does that refresh your recollection? They go, yeah, it's dated at the top, etc. Okay. So present recollection recorded is what the witness is actually preparing the notes that they've taken. Refreshing your recollection can be anything. Can be a photograph, can be a phone call, can be a text message, can be a receipt, can be a letter, even though letters are typically hearsay. Let's say, did the state reach out to you when you made a request for records? Yes. When did they do it? Oh, I can't remember. Well, if I show you this letter, would that refresh your recollection? All right, now records. So again, we talked about records before because we talked about it in the context of authentication of records. So records are things like business records, educational records, some medical records, pharmacy records, drug screen records. Those records, the legal term is that they are kept in the course and scope of work. So that's the legal term, kept in the course and scope of the work. All right, word for word notes. Now, this is interesting because I think we're all old enough to know that you can never remember anything word for word, right? Like you just can't, like, unless it's like a real exclamation phrase where somebody, says that, oh my gosh, that guy shot a gun at me, or oh my gosh, that guy had almost hit me in his car, right? If it's some If it's some highly emotional event that there's an exclamation, very rarely are we going to remember word for word that we can put it down in notes. So which is another reason why we like to record, but as a parent is making their notes and their history, you want to be careful about having them assume that they're making appropriate word for word notes. But this also applies to caseworkers, because caseworkers love to make these notes that appear to be what other people have said word for word. And of course, remember, they are not typing it in right then when somebody's telling them. They're making notes and then they're going back and they're putting it in a computer. So always keep your eyes wide open for anything that appears to be sort of word for word in their notes. All right, demonstrative exhibits. Now, what is a demonstrative exhibit? It's something that demonstrates something. All right, the most probably things that you can think of is where they have a let me think of where somebody demonstrates something. Here's a good example. So I did a trial one time. It was a criminal assault case, and I wanted to catch the cop. And so while the cop was sitting on the stand, I said, "Could you draw for me the floor plan of the first floor where you walked in the house?" And gave him a pencil and paper. And so he sat and, he goes, "Oh, I'm not a very good drawer, but he kind of draws it out. And then you have him, which is a living room, which is a kitchen, where was the guy sitting, draw a circle there, where's a door, put an X on the door, where did he walk in?" That's a demonstrative exhibit. And I was able to win that case because this was a case in which my client was accused of assaulting somebody. But I forced the cop to sit down and just draw out what had happened, we could show that the person had lunged at him and he had basically hit him in self-defense. So that's what a demonstrative exhibit is. Now, children are sometimes asked to do demonstrative exhibits, especially in forensic interviews. They're asked sometimes to draw what their feelings are. And so they may draw, or what does your family look like? And they'll draw these little stick figures and stuff. So those would be demonstrative exhibits as well. Photographs, I've talked about photographs before. We love photographs. We love photographs. Any parent that's preparing to go to trial, photographs are incredible that tell such a story, even if you're in some situation where you're doing a jury trial. And then diagrams, that's kind of like what I talked about with drawing the floor plan, but it could also be a diagram of, let's see, a diagram. Hmm. Oh, a diagram like a chain of events can be a diagram, or like an organizational chart. Like if you're trying to, or another place I've used the diagram is family trees, right? A lot of times where you have two kids and this daddy and another kid with this daddy and an aunt over here and an uncle over there. I've had people actually on the stand like, okay, let's just draw out kind of a family tree so the judge can incorporate and knows who everybody is. Remember, the trial is telling a story. It is telling a story. And the more clear you can tell that story and the more engaging that story is, the better it's going to be for the parent. All right, so what are kind of tactics are we going to find with opposing counsel? So, first of all, I think I mentioned this before, but they will call the opposing party with hostile interrogation. The CPS agencies love to call the parents and put them on the stand. And they call the parents to put them on the stand so that they can be hostile and arrogant and cross-examine them and wear them out. Okay. So they'll call an opposing party. We've through the course of the years, I have had some judges who used a courtroom procedure that I really liked. And that is where that judge said, okay, you're going to call your own client, you're going to call your own client, and then you'll put on the rest of your witnesses. They used to do that in divorces, which was actually a whole lot more fair because you were able to get your own story told. without having it, be in through cross-examination. They like to deflect facts. Now, what does that mean, deflect facts? Well, unfortunately, you're going to see it. You'll know it when you see it. Okay. You know it when you see it, because what you'll see is how they twist around the facts that occurred to make it look like something else, right? They may try to make it look like something else. I'll give you an example. Client, a mom, they were trying to make a big deal that she had had an auto accident and she had actually hit a street sign. Okay. Now, the truth is, it was dark. It was at night. She went out at night. She was tired and she just turned, she just turned. She just hit it, right? But they tried to make it sound like, she was in a big drunken stupor and she couldn't drive and her kids were in danger. Her kids weren't even with her. Okay. So they tried to deflect the facts to turn them into a different type of narrative. They also like to ask questions repetitively to sort of confound the witness, and they have a very twisted way of doing it. So they'll ask a client again something like, when is the last time you took your child to the doctor or something? I don't know. And then they'll go into a whole different topic, but then they start circling back around to the child's medical condition. And if the parent says, let's say, well, I haven't, it's been several months since the child's been to the doctor. But then if the CPS agency is trying to make out a case that the child has some type of medical disability, and then they start questioning the parents, particularly, let's just say, the child has some autism or Asperger's or something, and the parent is trying to make it sound like they're a good caretaker, then they'll circle back around to that question about, well, but you said you haven't even taken him to the doctor in months. Okay, now we know that may be totally irrelevant, because you can have a child who has a disability or some type of vulnerability and still not have to see the doctor on a regular basis. So, but they try to make it look like, well, they've asked you that question before to nail you down to say that the child has not been to the doctor in several months. Then they try to make it look like the child has a vulnerability and you're not taking care of it because you haven't taken the child to the doctor. They also like to argue with the witness. uh, they'll say, well, I thought you said earlier, blah, 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 blah. So, this is just intended to take the catch the witness off guard, to have them struggle with something they said before. And honestly, I'm going to tell you, I know about this because unfortunately they made me a witness in my own fake criminal case. But it's very hard. You, as a witness, as you sit up there, you're not taking notes on your own testimony. So it's very hard for you to remember what you really said 5 minutes ago. And you start questioning in your own mind, like, well, did I say it wrong before? I'm not. And also, we say things wrong all the time. We open our mouths and we think we said something and we didn't say that at all. Now, if you have a really super, super, super good attorney, they're watching for all those things and they'll correct you along the way. But the opposing counsel likes to get into this very hostile, almost argumentative stance with the witness, just to have them distracted and kind of weaken their attention, and then actually just question themselves. So they'll also love to use adjectives to commit the witness to an opinion. So what does that mean? Okay, so is your son smart? Yeah, my son's smart. Okay, so then, 5 minutes later, you're going through some grades or school activity, or let's say your son got a disciplinary report, right, at school for bullying somebody. And so, hang on. And so, they start talking about that, and then the attorney will turn around and he says, yeah, but you said your son was smart, so you really don't know your son at all, do you? So they love to try to get some type of adjectives out there to commit to you have an opinion. And the thing that you really have to work with witnesses on is you have to say, we learned adjectives in third grade. Don't commit to adjectives, right? Is it a sunny day? Is it a cold day? Were you traveling fast? Was your child feeling sickly, right? You want the facts. You want to put the facts into evidence. So, was your kid sick yesterday? Don't say, yeah, my kid was sick. You say, you know what? He had his stomach was bothering him, or his throat was a little scratchy, but didn't seem to be that serious. Also, so then pressing for an emotional response from the witness. So opposing counsel and DCS and CPS attorneys are grand at this, is they want the parent to become emotionally liable during a trial so that they get upset easy, so they can again, frustrate them, lose their focus, lose their attention. If a witness cries, I mean, if I'm an attorney, I'm just like, can we take a break, judge? Now some judges are really good and will do that automatically if a witness becomes too emotional or too, shattered throughout this. But it's okay for a witness to say, just to stop and take a breath and say, judge, I really need a break. So, again, that's training our witnesses to be prepared. And they also love to ask compound questions. So a compound question is pretty simple. It's just two questions in one. So they'll say, well, didn't you take your child to the doctor the other day? And after you took him to the doctor, you is isn't it correct that you uh, took him to the ball game without a coat? Okay, that's a fairly simple one because that one you can sort out pretty easily that it's two questions, but listening for compound questions is very critical. So, listening is an incredible skill to teach people when they're on the witness stand. They have to listen to the questions that are being asked of them. When I had my clients on the stand, I would say to my clients, listen to my question. There's a specific reason that I'm asking you that question. And I'm asking you the question because I want the answer to that question. And if I feel like we need additional information after that, we will expand that at a later time. All right, so objections to testimony. We talked about that before, but we're going to go through it again. Here are some objections. Again, this is a great thing to take notes on because you want these in your mind all the time. These are things, again, attorneys are not even that good at some objections. So the first one is just argumentative. Object, Your Honor, it's argumentative. So when they just begin to argue with the witness or try to force a witness to change their response to a question. Second is ask and answered. I'm not sure if you've heard that before. Again, as I talked about in a prior training, we looked at the Johnny Depp hearing in which Amber Heard was on the stand, and every single question there was an objection to, and the attorney who made those objections did a really good job pointing out those objections. I mean, she did not miss a beat, and it was very distracting. And you can see from that how distracted Amber Heard was, that she was not able to get on the record the things that her and her attorney had practiced. So ask and answer just means that question's already been asked. And, that's when somebody asks a question, opposing counsel asks a question, and they don't like the answer. And so they'll ask it again and they'll try to ask it in a different way, but at some point, there just needs to be an objection. That's already been asked and answered, and they need to stop being, and then it becomes argumentative with the witness. Cause for hearsay. So we talked about hearsay before, which basically hearsay is an out of court statement that somebody's trying to get in as evidence in the present hearing. So if you have a mom who says, well, the doctor told me, that's hearsay. Okay. So if you have or the teacher told me, or, the grandmother told me. So that is hearsay. Now, there's a few exceptions to that. I'm not going to get into them here because I don't want to get us off track, but we'll spend some time talking about what the exceptions to hearsay are. Cause for an expert opinion. All right, so the mom comes in and she has a disabled child, and she is like, well, my child has something, something syndrome. Okay. And so the other side can say, well, that calls for an expert opinion. She's not a doctor. She cannot testify to that. So we have to talk about specifically what are the things that the parents' limitations are on, which is again why we looked at getting records properly subpoenaed and authenticated so you can have them put into the court record. Relevance and probative versus prejudicial. So relevance is objection. You just say it's not relevant. It isn't relevant. Objection to relevance. And so relevance is when they get too far afield and they are not talking about the issues in the petition. Now, here's how that works in a CPS litigation. So, CPS has filed a petition for dependency and neglect. And they allege, mom was drunk driving and she doesn't feed the children and whatever. And so the uh, when the parent is testifying, they start testifying about how they about their experience over the past 3 years of feeding their children or whatever. So, the state's going to try to object to relevance, but they're going to say that doesn't have anything to do with the time period that we're talking about. Well, the overall ongoing care of a child is relevant. And so we have to, again, get the parent's story on the stand. So when it is relevant and when it is not is a very broad brush. If you have an evil court and an evil judge and evil players, they're going to try to object a lot on relevance just to keep it out, right? And then kind of what sits beside that is probative versus prejudicial evidence. So let's say mom had a DUI 7 years ago, before this, maybe even before the child was born. You never know with these guys. And so there is an objection which would say that that evidence is not relevant and it is more prejudicial than it is probative of the facts that we are working on here today. So, what is the probative value of a 7-year-old DUI in a case where there's been nothing since, and you have a case where the parent is charged with DUI in 2020? All right, assuming facts not in evidence and lack of foundation. So, a witness is to testify about what they know. What is their knowledge? What did they see? What did they hear? What did they uh, what did they do as a result of what happened? Okay, those are the foundational elements of testimony. It's your experience. It's the witness's experience. And so there are witnesses who love to talk about, again, go back to the first slide. Courtroom testimony is not a conversation. It's not a conversation. So they can't assume facts that are not in evidence, and they have to have a foundation, and the foundation is what is their experience. All right, so I'm going to, and then compound questions. So compound questions is kind of like what we talked about before. It has more than one question in the question, and it gets tricky sometimes. So you have to just really listen. So what's another compound question? Like, so isn't it true you drive a red car and you have a purple hoodie? Well, that's two questions, okay? And you don't want to ever just say yes, because you want to be extremely clear. So you say, yes, I have a red car. No, I don't have a purple hoodie. So that's kind of a compound question. All right, so I'm going to give you a kind of an example of something I just recently learned about. I was watching a extended interview by a gentleman who's an attorney, and he was the attorney for a young lady who testified. I'm not even going to use her name here. I'll use the bad player's name here. She was a young worker in the White House on January the 6th. And she testified, she was called to testify at the January 6th committee. And she went and she testified. She had very limited knowledge, very limited personal knowledge about anything that had happened at the Capitol because she had never been over there. She had been at the White House earlier that day, etc. Well, this girl, and poor girl, I think she was very vulnerable. She was very young. She was trying to figure out where her place in this world was going to be after this experience. And Liz Cheney got a hold of this girl through some devious means, which I think came through Signal or Telegram or something, and basically convinced this girl to come in and have another hearing and say that she had heard that President Trump had grabbed the wheel of the car and choked a Secret Service guy. It was totally made up. Now, did she hear some people talking about that? Maybe she did. Who knows, right? I mean, everybody was talking about a lot of crazy stuff. But what the reason it got worse is because she had not testified to that at the first hearing. And then in another deposition, she testified to that, and it made it look like her attorney had told her to lie. And her attorney got in big trouble and was had to face some very serious ramifications under this under the supposition that he had told her to lie. Now, the interview that I listened to was the attorney, and here's what the attorney said. He said, "Well, when she first came to see me to prepare for her testimony, she started talking about how other people were talking about what had happened, and I told her, look, stop right there. When you testify, the purpose of your testimony is to talk about what you know, what you saw, what you heard, where you were, who was there, what time of day was it, what did you observe in demeanor of the people. Your testimony is not about what other people have told you." And so she did not disclose that that's what her attorney had said. And so she ended up testifying where there was a lack of foundation, where it was not uh, uh, re- relevant, and the prejudicial value had more than the probative value. So because it was a congressional hearing and not really a courtroom, the exact rules that we're talking about here are different and they're much more expanded. But that's a pretty good example. And when I listened to that interview, I really felt for that attorney because I could absolutely see that happening. So if a parent goes in to talk to their attorney about their case and the attorney's trying to go over what the allegations are in the petition, and then the parent starts talking about hearsay, it's not unusual that the attorney would say, look, that's not admissible. You can't get into that. So we've got to focus on what you know. So this is how complex it is and how you have to try to sort this out at every juncture that you can. Oh, we're at 10 already. We're moving kind of slow. All right, the rules of sequester or sequestration, it's called. That is where you exclude witnesses from the courtroom. Now, the parties can be present in the courtroom. Experts can stay in a courtroom. Unfortunately, typically you would have to pay for an expert to sit in the courtroom. The only time you would really, in a CPS case, probably need an expert in the courtroom is where it could be a mental health expert. It could be a medical expert, maybe, but very cautious about having experts stay in the courtroom. Unfortunately, because it costs $2,000 or $3,000 a day to have an expert sit in there. Now, the agency can use a caseworker as the agency representative, and then they're allowed to stay in the courtroom. I hate this. I hate the fact they are really not the agency. They are a witness. They started doing this about 15 years ago. It's so frustrating to me because they get to listen to everybody's testimony, but that's what's happened. That's the way they're going to do it. The agency are going to let their caseworker, their key witness, sit in the courtroom the whole time and even hear what the other witnesses say. After their testimony, they're allowed to stay in the courtroom. However, a lot of these juvenile court proceedings are closed proceedings. And so they are typically kicked out anyway. And then others who are not witnesses can typically watch a trial, except in a CPS case. A lot of times they're closed proceedings. So where there are closed courtrooms, there are still provisions that CASA interns, trainees, etc., are often allowed to sit in there. I hate that. To me, it's like if it's a closed courtroom, it's a closed courtroom. I don't want interns in there. I don't want trainees. I don't want CASA. But unfortunately, you'll probably get overruled on that, at least for now. So non-party witnesses, and so you have to give notice of non-party witnesses. You have to exchange it in discovery, in pretrial orders. The main principle of the trial procedures is that you don't have trial by ambush. That everybody should know by the time they go to court and have a trial what's going to be said. That's the key thing about preparing for trial. You should know what discovery documents there's going to be. You should know what who the parties are. You should have the opportunity to already ask them questions or to call them or depose them, however, depending on how critical they are. Witnesses can be interviewed prior to trial. A lot of them are not very cooperative, but you can make a phone call to a witness as long as it's not a party and say, hey, I know you're involved in this case. I'd just like to ask you some questions. Witnesses can refuse to talk ahead of trial. And if a witness has an attorney, of course, you have to go through that attorney. Depositions ahead of trial, discovery depositions and evidentiary depositions before trial are important. However, extremely expensive, and you may or may not need them, depending on how critical that witness is. Investigation of witnesses prior to trial, doing their background, their conflicts, their biases. This is actually pretty important. A lot of people now have People Search and Truth Finder and things where you can go back and you can get a history of that witness. And you might want to go look at their employment history. And it might be important that you have a person who's doing supervised visitation, and 3 years ago they worked with the department. And so you want to ask them about that. Isn't it true you work for the department already? And you might be biased towards the department. The recollection of facts, we talked about that a little bit. So with witnesses, with non-party witnesses, you can refresh their recollection. Again, when did you go to Taco Bell with the dad? I don't know. Well, if I show you this receipt from Taco Bell, would that refresh your recollection? Oh yeah, it does. It shows right here. So now can you tell me when, etc. Character witnesses and witnesses on habit, routine, and motive. So there are some very distinct limitations on what's called a character witness generally in a trial. However, because CPS cases are about parenting, basically witnesses who can talk about parenting specifically are not really character witnesses. They're really witnesses on habit, routine, and motive. Okay. So I'd love for parents to have witnesses. It's kind of a challenge. Do you have people who just come and say, yeah, I've seen them with their kids a ton and they're great. Like, I see no issues here. Expert witnesses. So for expert witnesses, there has to be a pretrial discovery of experts. The discovery request under Civil Procedure 26. Now, I am quoting Tennessee rules. However, every single state has civil procedure rules. Every single state have rules of evidence. Almost all the states follow the federal rules of evidence almost pretty clearly, pretty succinctly, but you will want to learn some of these particular things. So if you're in the state of Nebraska, you can Google basically civil procedure Nebraska experts, right? And get the specific rule, because there are things in a expert disclosure that are pretty specific, their background, their history, what they looked at before they formulated an opinion, etc., and then what their opinion is. So court-appointed experts And retained experts are different. There are rules of evidence about experts, and technically, court appointed experts are only supposed to apply when the parties cannot get their own experts or the parties cannot agree. Retained means you hire yourself. Oh, excuse me. So if the parent wants to hire their own expert, that's considered a retained expert. But in both cases, whether it's a retained or court appointed expert, the rules of evidence for experts apply. Oh, I'm sorry, I got the hiccups. Now you're going to have to bear with me. All right, fact witnesses turned expert, doctors, caseworkers, etc. So this is a little bit tricky because we talked about getting medical records. So let's say you get your child's pediatrician's records for the past 3 years, and you authenticate them with a subpoena. You have that to put into the record, and there's a diagnosis in those records of ADHD. Okay. And so you want to have some discussions about how that affects, or DCS wants to talk about how that affects parenting or your lack thereof. And so now, just because there is a diagnosis within a medical records, it is not the equivalent of an expert opinion on what the needs of the child are if the child is suffering from a disability or vulnerability. So then the doctor may have to be put under a deposition for expert to get his expert testimony. Kind of the same thing with caseworkers, but it's a little bit opposite. So I have had in a couple of cases where they've tried to qualify the caseworker as an expert. And again, this is why I know I say this over and over. I'm always saying, well, again, you need to be doing this, you need to be doing that. And I'm sorry if that gets annoying, but it's also important. Pre-trial discovery, asking in advance, who are your experts? Because you want to know before you get to court whether or not the state agency is going to try to make their caseworker an expert. And why would they do that? Because they want their caseworker to render an opinion about what a lousy parent you are. That's why. All right, obtaining curricula vitae and resume of expert is very important. The curricula vitae is a little bit more extensive than a resume. It will give like different types of training that they have done. It should give any publications that they have written, any research, etc. In federal cases where they've testified as an expert needs to be included in that. And so the reason the curricula vitae can be important when you have some very sophisticated experts is because if they have not studied or they've not given instruction, or they've not participated in trainings on that particular topic, it weakens their testimony. So, for instance, I had a case in which a child suffered from a neurological disorder called PANDAS. And the opposing side made us go all the way to Florida to do a deposition on this medical expert, their medical expert on PANDAS. And so they provided us this curricula vitae that was like 45, 50 pages long for the past 20 years of all the stuff he had done. And I don't think they gave it to me in advance. I can't remember. Maybe they did. But anyway, as I went through all this research and articles and everything and teaching and everything that he had done, he had never really hit on that topic. That had never really been a topic of his research. So I was able to undermine some of his testimony based on that. Disclosure of previous expert testimony. So I'm not exactly sure why I have this in there. Disclosure of previous expert testimony. So that really probably has to do more as to whether or not there's been any prior cases in which have been involved with CPS, and you want to make sure you have any disclosed any other experts that have testified in the case. What did the expert review or observe? And this is why you get a Rule 26, because you want to know what they looked at to be able to formulate an opinion. And that is part of the Rule 26 procedure. Their qualifications and narrow topics and opinions, such as psychological medical. I just talked about that. the use of publications or other opinions for cross-examination. Oh, I love this one. Many years ago, there was a therapist on the stand, and she was testifying about a child who had disclosed some uh, mm, kind of some bizarre disclosures that were supposed to be have some sexual undertones or something. But the child was very young, like 4 years old. The disclosures were a little, almost borderline nonsensical. And when asked those questions repeatedly, it changed a little bit. And so I was able to pull up a publication and a research experiment from probably 15 years ago that was called the mousetrap experiment. And that is where they took a bunch of children who were about 4 or 5 years old, and individually, they talked to these, had a little conversation with these kids. And in this conversation, talked to them about the time they got their finger caught in the mousetrap and how it hurt them. And, they just spent, 4 or 5 minutes talking about it. And 3 months later, these same children were asked the question if they'd ever caught their finger in a mousetrap. And every single child said yes. So I was able to cross-examine this expert on the mousetrap case and talk about the retention of true memories versus false memories and win the case on that. All right. Also identifying conflicts of interest. If these therapists, particularly hospitals, are getting money from the state agencies, which a lot of them are. So we'll have to sit down in one of our trainings and talk about how do you find out the conflicts of interest? Where do you go get that information? Of course, you can always ask them, but you really would like to know that before you get to trial. A party is a witness. Warning to party witnesses. Court testimony is not natural and not a conversation. Not a conversation. It is not a conversation. I don't know. I can say that 16 times. Court testimony is not a conversation, and the parent must always remember that. I've got this little friendly picture up here because sometimes attorneys will try to pull their guard down by looking like they're being friendly. Be prepared to be emotionally triggered. Listen to the question and pause, and be aware of deflector tactics such as twisting the facts, twisting the timeline and circumstances, and don't be afraid to ask for a break. Listen to the question and pause. Just take a second. Sometimes witnesses even kind of repeat the question. Now that can get really annoying, so you don't want to repeat every question, but you can isolate the question. So if the question is kind of a run-on question like, oh, I was looking at your records the other day, and in your records, I noticed that you said that it had been an extensive time investigation, and during that investigation, 3 people had been spoken to, and one of those 3 people were very concerned about the lack of supervision in the backyard. And so, is that all of that true? Okay, now that's a really long question, right? And you want to be very careful about that. You don't want a parent to just go, yeah, that's true. You want the parent to go, okay, hold on a minute. Let's see. So, was there an investigation? Is that part true? Were there 3 people spoken to? I don't know if there were 3 people spoken to. Did one person say? Well, I don't know. One person said that. Who said it, right? Where was there lack of supervision in the yard? So listening to the question and pausing and breaking it down. And if you're asked to say, isn't all that true? Or is there anything about that that's incorrect? That's what they also like. Ask a really, really long question and then say, now, is there anything about that that's incorrect? And so that's a trick question because you want to sit back and you want to say, okay, can you break that down for me so I can make sure that I'm being accurate? Party is a witness. Party. Now, party does not mean party like it's your birthday. Okay. Party is a witness. The party is the person who is named in the petition, right? Like the parent's name is on the petition. They are the party, but it is not party like it's your birthday. Dress appropriately for court. This is what not to wear for court. Dress appropriate for court. Be on time. Anticipate being called as a witness. Look at the judge when you answer a question. Sometimes you look at the attorney, but engage the judge in your responses. If there is an objection by an attorney, stop. Just stop and wait for the objections. Wait for the objection to be ruled upon by the judge. Avoid hearsay. Don't say, well, so and so told me, or I heard this, right? You want to avoid hearsay. There will be times when hearsay will be asked. They may ask, well, did so and so tell you? Okay, so you know, now there's a couple I had as an objection earlier. It calls for hearsay. And so an objection, if an attorney says to a parent, well, did so and so tell you blah 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 blah, then you can object. Well, it calls for hearsay. Well, why do you want to do that? You want to do that because you don't want they're not going to recall things exactly and verbatim, so you don't want them to get tripped up. So, but they can ask a question like when somebody, did you have a conversation with so and so? As a result of that conversation, what did you do when they gave you, when after you talked to them? So, wait for objections, avoid hearsay. Okay, I don't recall is a very dangerous response because if the parent doesn't recall, what that does is it opens the door for the opposing party or agency to fill that gap, right? So if the parent is asked, did your child get an F in history last term? And the parent goes, I don't recall, I don't remember. Now we have a blank, right? It's like leaving a blank. And so a caseworker comes in and says, well, I saw the report and they got an F in math. So you've just totally lost it. So I don't recall is extremely dangerous. And you want to, if you cannot recall, you want to be able to give some context. Okay. So for instance, did your child get an F in history last semester? Well, I don't remember the grade in history, but I believe if it was an F, I would recall that because I would have had a serious conversation with my child. Okay. So I don't recall. I hate those words. I hate those responses. When people give them to you, it leaves a gap, it leaves a blank in the evidence. And I've used it to my advantage. Certainly, I'll tell you, if the caseworker says, I don't recall, or I've had a doctor ask a doctor, well, what was the condition of the patient on such and such day? And if they say, I don't recall, they've left a blank, they've left a blank there. So I don't recall. Write that in really big letters if you're taking notes, and then put like the circle with the line through it, for no. All right, allow your attorney to fix the errors on cross-examination. If you have a really good attorney, they're going to clean up. They're going to clean up your testimony. All attorneys make a notepad, and I'll show you when they're making notes of a witness's testimony. Typically, I don't can you see this? Can somebody, you guys can't see this, can you? I'll show you after we get done. Okay, so they have a notepad and they're taking notes and they've got a line drawn on their paper. And on one side of that line are sort of the answers and questions that are going down, probably very sloppy handwriting, big handwriting, using tons of paper. And then they're making some little stars or some little notes in the other column where they want to go back and kind of clean that up. So a good attorney is going to go back and clean up a lot of things, especially on these, like, I do not recall. If they realize how dangerous that is, they're going to fix that. Child witnesses. So children under 12 years old or children under 12, you have to have basically a competency questioning as to whether or not they're competent to even testify about memory and understanding the truthfulness of how important it is to be truthful. Children over 12 generally are considered to be competent to testify. You still might want to ask them those questions And they have some communication skills, but honestly, very varies a lot as to what their communications are going to be. So they should still probably be voir dired for truthfulness, which is very simple. You just ask a child, do you understand what telling the truth is? You understand you're called here today to tell the truth. And if I tell you the grass is blue, is that the truth or a lie? Right? So you just go through a few questions like that. Sometimes they like to take the testimony of the child outside of the presence of the parents. Ugh, this is horrible. I mean, of course, if you have a child that's subject to abuse and they don't want to talk about abuse in front of a parent, but the problem is that the parent and the attorney have to sit side by side. The parent's attorney has to be able to ask the parent questions. So there are a few ways to resolve that if the court or the guardian ad litem insist on the testimony being taken outside of the presence of the children. You can always ask the court, just say, okay, well, we would like to have the testimony taken. We'd like to have a short break so that we can talk to our clients and come back and ask some follow-up questions. That's one way that we've done it in the past. Sometimes they let the parents be present. It's just, it's sort of a preference thing. Anything that could influence their testimony, you kind of have to ferret that out of their testimony. Has anybody talked to you today about your testimony? Were you asked to write down or make any notes? So, did anybody promise you anything? So those are the kind of questions you want to ask of children. And there are certain hearsay exceptions. Children's testimony about abuse is a hearsay exception. Now, that doesn't mean for the child. That means for an adult who says the child told me this. Okay. So, if a child is 12, I think it's 12 and under, a person can testify the child told me the child was abused. However, the child has to be available to be able to ask questions to, at least in Tennessee. If a child is over age 13 or over, the child is the one who actually has to testify about allegations of abuse. And finally, and this is kind of a trigger question, you have to be very careful, but sometimes with children, you just have to say to them, is there anything else you would like to tell the judge? Now, I had one little child say, yeah, I like cows, or, I really like my dog. But there are also children who just want to say, do you think I can go home? When can I go? When can I see my mom? When can I go home? Children are typically very timid. And so, the opposing party, they like to ask them questions that really put them on the spot, like, how do you like it? Don't you like your foster home, don't you? Do you like it there? Is it very comfortable for you? So, it's very torturous for children. Actually, the whole process is. So some of the obstacles for children in court is their memory of events. The best thing to do is to try to connect memories to emotions. Were you happy? Were you scared? So if you're trying to, let's say it was a visitation with their parents that they had during the process before they got to trial, and they said, do you remember the visit you had with your mom in October? And they're like, no, because kids are like, no, not really. But then you say, well, do you remember your mom bringing you a plush melon, right? Or a plush pillow, or with a big teddy bear thing. And then so you have to know some of those details, right? And that's why, again, it's important that parents take notes and they have things down that will help trigger the child's memory. And so then the child go, oh yeah, I remember that. Okay, so let's, take you back. Can does that help you remember a little bit about what happened? And they still may say, like, I don't remember a lot. I said, well, can you remember how you felt? And so you can get them to say, yeah, I was happy. I was happy to be there. So their feelings about their parents. Well, and we have so many children are coached. I just have to say, after they've been in foster care, but we do want to work out of the children some of their memories about their parents, about things they used to do with their parents, if their parent was engaged in soccer or hunting or some type of activities. The children are always afraid of uncertain outcomes, and I like to just ask them that. So, as you sit here today, are you a little bit concerned about you don't know what's going to happen? And, they're going to say yes. And I think that's important to put on the record so that we know that children have some anxiety about their status. They have an inability to understand the separation experience. Let's just call it what it is. Separating children from their parents is absolutely traumatic. It happens. Children that we don't really have really good psychologists who have talked about that to date, and I wish they would. There's been a few who started to. There are separation anxiety, uh, research papers, etc. But separating, understanding what that separation experience is like, should be part of the child's story. And also, the child is facing a room full of authority and strangers. It's very uncomfortable. There's just nothing, if it's uncomfortable for an adult, it is exponentially harder for children. And as I said, of course, they can be influenced. All right, so sometimes it's even hard to go ahead. Yeah, sorry for the distraction there. Uh, so unfortunately, sometimes when children are put in foster care, the reality is that we can't get access to the child for a pretrial interview. And then the guardian ad litem, who's really, I mean, really, they're supposed to represent the child's best interest and not the child. But most of the courts now say, well, that's a child's attorney, so you can't talk to the child without their attorney present. I don't think that's correct, but unfortunately, that's where we are, and that's what we have to live with. So that's a bit of an obstacle for parents because, their child has been held hostage in a system for months and months. I just read a opinion out of the Court of Appeals on this case that had taken 9 years to get it to trial. And of course, this child who was like 2 years old at the time he was taken, he has no reality that it's associated with his parents and his grandparents. The children's right to an attorney advocate. The children have a right to advocacy. The guardian ad litem is for the best interest of the child. The attorney ad litem or preference attorney should be advocating for the child's desire. If the guardian ad litem does not do that, the child needs their own attorney and you can ask for it. Preparing your client as a witness from day one. We have talked about already about it's already 4:30. We have already talked about outlining narrative, historic events, client list of all potential witnesses, even the good ones and the bad ones. The client continuing to document ongoing events, calendaring, journaling, client gathering exhibits, photographs, things, clients reaching out to source witnesses for reputation and habit. Okay, so part of the conversation we've had before, that your client, your parent needs to start thinking about themselves as being a witness from day one. What do you need? What are we going to need? What do we need to overcome these allegations and show that the children need to be home? Engaging the client during trial is the client must pay attention. They need to listen to all the testimony. They need to have their own pencil and paper. They need to make notes. They should be making notes during the hearing. They should not interrupt their attorney. It's very, very hard. I've had clients tug on my, jacket while I'm talking. I always just shove the paper in front of them and pat the paper and tell them to write it down. Do consult. A good attorney is going to consult with their client before they sit down and ask the client to look at their notes. So you want to look at your client's notes to see if they made anything. And honestly, they're always going to learn something. You're always going to learn something about the case. And I think one of the prime examples that comes out is, when a deputy got on the stand and talked about putting the mother in a police car, and the mother went willingly. And little did I know there was an audio of the whole exchange that showed that it was not willing, and my client then shared that with me. So also while you're listening to the case, you need to identify what you're going to have to rebut and what kind of rebuttal evidence you're going to need. Pretrial motions. Oh, I love this, Amber Heard. Preparing the client for pretrial motions. So there are a lot of things that happen in a CPS case, and we're going to go through these individually in different trainings. There's a preliminary hearing or shelter hearing. There are restraining orders. There are motions to treat a child, permission to treat a child. There's visitation and relative placement hearings. There's permanency plan hearings, ICPC hearings, and depositions of clients. So a lot of activities happen before you even get to trial. So the attorney's overwhelming preparation trial obligations prior to trial. They have exhibits to do, pretrial motions, prepare and follow up on all the subpoenas, review the records for cross-examination, pretrial disclosures and brief, and review relevant case law. The client preparation, which should begin at least a month prior to the final hearing, is reviewing the client's narrative, reviewing the client's notes, review the the attorney prepared pretrial disclosure and brief, and review evidentiary objections such as hearsay, refreshing recollection, etc., and demonstrative evidence. So these are really two totally separate things. Attorneys preparing for a trial is overwhelming, intense, very intensive for an attorney, and only one little tiny portion of that is preparing the client. And so that is why we have got to get these clients and these parents on board getting prepared when the case first opens up so that they can become professional at assisting their own attorney in preparing, and that they have the notes to be able to share with their attorney, to point out some highlights, etc. And also the client needs to read the pre-trial brief of the attorney. And I have told many of my clients, especially if I run short on time, like I'm preparing a pretrial brief, which is going to tell you exactly what I want this case to look like, exactly what I want the proof to show. And so you need to read it, highlight it, understand when I ask you a question, that's what your answer should be. Expert preparation and discovery, pretrial discovery, request, opposing expert, the subject matter that the expert will render an opinion, the substance of the facts and opinions, the summary of the grounds for each opinion, the qualifications, including publications of the last 10 years, the list of other cases, the statement of compensation for opinion and testimony. Ooh, those are all things you need to request from the opposing expert and have your own expert prepared to respond to. Same thing right below that. Decide what you need to rebut on from the opposing expert, and what kind of expert are you going to need, how to prepare and provide all records to the expert, review the expert opinion, and interview the witness to understand the opinions. I spent, oh my gosh, so many hours on the phone with medical experts over the years, tons of them, tons of them. But just getting an expert opinion and looking at it is not enough. And then, of course, experts have to be paid. So there always has to be some type of provision for that. And there are some court grants that are available. Experts in depositions, the planning, the logistics of it, the payment, the engagement letter or contract between attorney and expert, deposition, transcript, video. These are all just logistics with experts. Court appearance. Some doctors are exempt, so you probably have to do a deposition. The court accommodation for experts. In other words, can you put them on a particular day and particular time so they're not sitting around and waiting? And then finalizing the expert report after you've had the discussion with the expert before you turn it over. The cross-examination of experts, you want to prepare your cross-examination in your pretrial discovery. You want to obtain the report. You want to review the report with your own expert so that you know what questions to ask. You want to challenge how the scope of the opinion is, how broad the opinion is, how many things they're trying to cover, or if they even have a specialty in that area, and challenge with the publications, as I've already talked about. Okay, so the challenge with the scope of the opinion, let me give you an example. Child abuse pediatricians are not experts in anything. And so if you are cross-examining them, and let's say it's a fractured rib case, you want to be sure that you have on the record that they are not radiologists. They are not orthopedic surgeons. They don't have a specialty in bone tissue or bone injury, et cetera. So that's how you kind of trim down the scope of the opinion. Fact witness turn to expert treating providers. Expert opinions must be disclosed pre-trial. I just went through this week with somebody. They tried to turn a treating physician into an expert, and I objected to it because they did not disclose that person as an expert. The scope of the opinions of treating professionals must be limited within those to the services that they actually provided. So if they're giving an opinion as a treating professional, that is different than giving an opinion as an expert. In other words, a treating professional can say, well, it's my opinion this person has Crohn's disease. But that treating professional cannot give the expert opinion on all of the ramifications, all of the treatment options, et cetera, for Crohn's disease, unless they have qualified pretrial as an expert. The basis of their opinion is limited to their own evidence. Caseworkers, I've already talked about, they are trying to turn these caseworkers into experts. And if we are preparing the case ahead of time and asking for expert opinions, we'll know that in advance, and the parent can be protected from that. All witnesses, clarity of their testimony is important. I don't recall. Write that in big letters, put an X through it, leaves the opportunity for opposing parties to fill in the gaps. And we've talked about that. Refreshing memory, notes shown to a witness. Now, if they're refreshing the memory, the opposing counsel will get to see those documents. The recollection, dates, places, persons, how long, frequency. The best way for parents to have recollection of dates, places, persons, et cetera, is to have their own diary, their own history that they've generated. Never happened. If that happened, that would have had an impact on you. Okay, so the never happened response. So yes, especially in a CPS case, let's say they've challenged that some injury occurred and the parent is asked the question, well, did the child fall off the fence and cause this injury to their shin? And the parent says it never happened. Okay, so what you want to make sure that you do is you close that gap by you say, if that would have happened, what would you have done? Or if that would have happened, how would you have reacted? What kind of impact would that have had on you? So don't leave gaps in the evidence. I don't recall and never happened are too big a gaps. Okay. We want to fill in the gaps, which is with as much information as we can. Pronouns, it's very easy to confuse the characters. We've talked before about all the characters that are involved. They is nobody. So we don't want people to use the word they when they're testifying. Even he and she is very dangerous. Kind of the rule of thumb is, if it's within one sentence, you can use they, right? Like all of the members of the DCS staffing were present and they did this. Okay, that's a decent they, but you can't just randomly use those words they, he, and she. Adjectives used to commit to an opinion. We've talked about that. That would be horrible, wouldn't it? Is a perfect example. Nothing is horrible. It's all in the mind of the receiver. So, again, no blanket statements. Identify the details, respond to the details. Witnesses, their evidence, their testimony must be competent. There must be some foundation. They have to have personal knowledge, and they have to lay a foundation on how they have that knowledge. So, for instance, was there a fight in the playground at school? So let's say a parent is asked that question. The parent can't just say yes. The parent has to lay a foundation and say, well, I was at the school that day because I needed to do such and such, and I saw this. So there has to be a foundation laid of how they know something. Hearsay, again, what somebody says outside of the courtroom, and the exceptions, questions, directives, exclamations, statements about mental state, statements for purpose of medical diagnosis, statements of reputation or character. We are not going to get into all of those in detail today because that is a whole training in and of itself. But there are exceptions to the hearsay about what somebody says. But generally, the general rule is a witness cannot say what somebody told them outside of the courtroom. And privileged communication would be any communication they have with lawyers, clergy, psychologists. There is some marital privilege as well that they can object to privilege. All witnesses cross-examination, leading questions are questions that you ask and then you say, well, isn't that true? Isn't it true that you picked up your child from school on Tuesday when you thought DCS might come and talk to them? Well, that's a pretty extensive question. So again, you want to break it down and say, well, I didn't know that exactly, and I picked up my child because. So answer the questions as to get the correct facts before the court. Attorney statements of facts. When an attorney makes a statement, is there anything this that you disagree with? So I've already kind of said that. Attorneys love to do this. They love to do this. They love to say, well, again, like the example I gave earlier, give this long description of something. Oh, isn't it true? There was a big investigation and 3 people were interviewed, and the one person said that blah, 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 blah. Now, is there anything about that that you disagree with? Break it down one part at a time. Answer the facts that need to be explained within the statement. Argumentatives when they just argue. Challenging conduct with condemnation. Again, they just want to mess with you, basically. Contradictory evidence, the witness's own statements and the statements of others. So they will try to put contradictory evidence in front of a witness so that the witness looks like they're not being truthful or being a liar. Establishing a motive, they try to confront witnesses on why they did what they did or why they did not do something, right? So it can be, DCS loves to do errors of omission, not just errors of commission. So they will try to establish motive by asking specifically why something was done. Again, a parent must be prepared to stop and think about what their response is going to be. And confirmation bias is about confronting the witness on the result they wanted. Well, this is great with CPS workers. They all want to, get their cases substantiated as abuse. I think they have scorecards somewhere on that. So they probably get more bonus points if they get more abuse allegations substantiated. So, sometimes that's a good question. So isn't it true that you really want this case substantiated as abuse, right? And they're going to say, of course, they're going to say no. And you can torment them a little bit about that, but the judge will probably cut that off very shortly, but it's true. All witnesses, techniques for all witnesses. Listen to the question. Listen to the question. Listen to the question. Listen to the question. Pause. Do not talk over the attorney and listen to the objections. Answer the question. If you are asked the time of day, don't describe how to build a watch. Listen to the question. Correct answers. If you remember the answer to a prior question, state that you need to correct or supplement a prior answer. And when would this happen? Let's say somebody's asked a question, did you eat at Taco Bell with John on Tuesday? I don't recall. And then further in the testimony and say, okay, so on Tuesday, here you went with John to Target, right? So is that oh yeah, that's the day we ate at Taco Bell as well. So I want to correct my prior answer, my prior response. So again, if the witness is well prepared, but you can't totally prepare them 100% for everything, there's going to be some questions come up that they did not anticipate. And answer when asked. If your attorney asks you the same question twice, there's a reason, just answer the question. So I had a client where I was asking him questions and he was giving me this funny look. And, at some break, he said, you're asking me the same question more than once. Am I giving you the wrong answer? And I said, no, I can tell when the judge is not paying attention. And if the judge or jury is not paying attention, you may be asked that question again. If there's some additional response that's needed, you would be asked the question probably in a different way. I think we're done. All witnesses summary. Ooh, goodness, you guys sat in a very long training today. I appreciate it. Testimony is not a conversation. Be careful, go slow, stay calm, seek to answer questions with clarity, correct answers if necessary, stay focused, stay calm, ask to repeat questions if you need to, ask to explain your answer. So if a leading question is asked and they try to get you to yes or no, you can say yes, but, or you can even say it's not a yes or no answer. I would like to explain. And stay inside your boundaries of personal knowledge, records, or expert opinion. And I believe that is the end. Yep, it is. All right, so we are going to go offline here. I appreciate you all's patience. Oh my gosh, that was so long. I think 32 slides is too long for a training. But we are going to stop